Thanks, Sarah. I'll try not to be too legalistic today. I've got quite a broad topic that I was, I guess, talking to Kelly about before the conference. So I think I'll start off talking briefly about the law and also the role of the Environmental Defender's Office, so it can sort of set the scene for the second part of the talk, which is more around the role of consultants and botanists, etc., in the process, but from more of a legal angle and a little bit of an ethical angle as well, to hopefully stimulate a bit of debate, and if I get time, a couple of case studies at the end. But before I start, I'd also like to acknowledge the traditional owners of the land in which we meet today, the Whadjuk Noongar people and their elders past and present. So to start with, who is the EDOWA? We're a community legal centre, a not-for-profit centre, and we like to call ourselves the state's public interest environmental lawyers. There's lots of other environmental lawyers running around town, working for government, industry, private practice, etc. We act for a range of different community groups in the public interest, and we do a range of work as well. We undertake litigation and provide legal advice to groups. We do community legal education, a bit like today, and also more bespoke education to community groups. We undertake environmental policy and law reform, so we're often consulted by government agencies on law reform initiatives and policy initiatives, and we do a lot of fundraising as well, and hopefully you've seen our current crowdfunder as well, and getting up to tax time, please donate to that. We're part of a network as well of environmental defenders offices across Australia. We were founded in 1996, and there's an EDO in every state and territory except Victoria, who have Enviro Justice. And the EDO's Australia network was established in 96 as well. So we're each independent, but we collaborate a lot on law reform initiatives and share ideas and learnings, and collaborate on national law reform submissions as well. So I said we act for a range of community clients. We act for some of the bigger NGOs, Wildflower Society, for example, Wilderness Society, Conservation Council, but we also act for a lot of smaller local groups as well. And we've got a number of cases and actions running right from the Kimberley. We act for a traditional owner in the Kimberley, through to Exmouth, right down to the southwest, including Esperance as well. So we've got a range of different clients on a range of different public interest law matters, which for me it's really interesting in terms of exposing myself to all the different challenges that environmental law and regulation poses right across the state. So what is public interest environmental law and the type of work that we do? For us, it's got its significance beyond a material or financial interest of a particular person or group. So often lawyers will act for a particular client and they're trying to achieve a particular outcome, such as development or some outcome. We obviously act for clients, but it needs to be beyond their personal interest. The clients are there working in the public interest, and our role is to advise them and provide them with legal advice in the public interest. It needs to involve a real threat to the environment. We're not going to run a test case just for the sake of it. It needs to have some threat to the environment, or result in a good environmental outcome, or result in an interesting, I guess, law reform initiative or a change to the environmental law. And it always needs to raise matters regarding the interpretation or the administration of the law. Again, a lot of legal actions will be run for the sake of getting an outcome. We need to take on board some of these broader considerations before we run a case. And a lot of that is as a result of our limited capacity as well. I'm the only full-time lawyer at the EDO, and we rely heavily on volleys as well to keep our practice going. So I like to say that we're there to use the law to protect habitat, particularly relevant to today's conference. I'm going to race through this quite quickly in the next couple of slides because I want to get more to the case studies. But some of the key elements of public interest environmental law internationally, I guess, and a lot of this comes through international conventions like the Aarhus Convention as well, and not all of them are in place here in WA, which is why we'd like to see a lot of changes to WA's environmental law. But things such as giving the right to have access to information, and not just through freedom of information processes. The ability for the public to have a say in what happens in relation to their community and in relation to the state. So participation in the process. Having an independent environmental impact assessment process and independent decision makers who are independent from the private interests of the developer or the interests of the community. Having a right to bring legal action, either through appeals to the minister or to an independent land and environment court, which we'd like to see, right through to taking cases to the Supreme Court and having access to do that in the public interest. Through the Mining Act, for example, the minister is required to take into account the public interest in granting tenements. So for example, we were just talking about Helena Rural Range. We were involved in a case last year where we challenged the grant of tenements in the public interest and ran that through the Warden's Court. We're yet to hear a decision on that, but that's an example of using the public interest in the mining space as well. And I mentioned a specialised court, so in some states such as New South Wales and Queensland, they've got specialised environmental courts where the public can go and ventilate issues in the open public. We don't have that in WA, we've got a more administrative process through the appeals convener, but we do have that ability to appeal decisions or recommendations of the department or the EPA, and we get involved in that a lot. Just put up this slide just to give, particularly for the botanists and consultants out there, just an idea of all of the different, or some of the legislation that your work touches on as well. And I haven't even put up the CALM Act, which was just talked about in the previous presentation. So it's not just the Environmental Protection Act that's relevant to your work. It can involve the Mining Act, as I just mentioned, the petroleum legislation, the planning legislation as well, and obviously the Commonwealth EPBC Act. And there are a range of different issues that that legislation throws up. And again, relevant today, it's mostly around habitat protection and land clearing. And it all doesn't just sit in the EP Act. And there was a debate in the earlier panel about, how do we streamline processes? Well, a lot of that is often driven by the laws that the agencies have to administer. They can't, sometimes they're constrained by the acts that they're operating under or other legislation that might be impacting their role as well. So we always need to bear that in mind. So for the next few slides, I guess, and a lot of people will be really familiar with this, but some won't, so I think it's worth just touching on parts 4 and 5 of the Act quite generally, just so that it's relevant to what I want to talk about in the second part of the talk. So the Environmental Impact Assessment process sits in part 4 of the EP Act, and there's also an assessment process obviously at the Commonwealth level. And EIA is recognised in international law as well, and it came about through international conventions such as the Biodiversity Convention, and it's got statutory relevance here in WA through part 4 of the EP Act. But it's only triggered for proposals that are likely to have a significant effect on the environment. And of course, significance isn't defined in the legislation, it's somewhat defined in the guidelines, but I'd say not perfectly either, but that's a call for the EPA to make when proposals come before it. But the process starts when a referral goes to the EPA, and it doesn't necessarily have to come from the proponent, and interestingly, under the law, the proponent isn't required to refer a proposal to the EPA. It is allowed to, and more often than not, it's the proponent that refers the proposal. But if the proponent doesn't do that, any other person can do that, and occasionally we would refer proposals to the EPA on behalf of the clients if they've got a concern about a proposal that's not before the EPA. Or a decision maker, so some other decision-making authority does have the obligation to refer a proposal that hasn't gone to the EPA if it considers that it's an environmentally significant proposal. So for example, if a mining proposal goes to the Department of Mines and Industry Regulation and it hasn't gone before the EPA, through their MOU it might form the view that it should go to the EPA first. Once the EPA gets that proposal, it needs to decide whether to assess it. And that's one of the only decisions that the EPA ever makes, is whether or not to assess a proposal. And that decision can be appealed to the Minister if you're not happy with it. But then once a decision is made by the EPA to assess a proposal, then all other decision makers are constrained in terms of making a decision under their approval. So those secondary approvals, as people call them, have to wait until the EPA Environmental Impact Assessment process has been completed. And it's an offence to implement a proposal while the assessment process is going on, apart from minor or preliminary works that the EPA has decided can proceed. So once the EPA decides to assess it, it sets a level of assessment. From our perspective, we'd like to see assessments at public review, so the public gets to have a say in terms of the assessment. And that also defines the scope of the assessment, and that's really relevant to the work that a lot of people in the room do, and in terms of the level of surveys required and the type of work and the type of analysis that has to go into play. So the proponent is required to prepare and finalise assessment documents with advice from botanists and others and consultants, depending on all the environmental factors that are relevant, and includes the survey information as well. And we need to remember that for points I'm about to make a bit later on. Hopefully there's public review, then the proponent's required to respond to the public review, the comments made through the public review. And then eventually the EPA prepares a report and makes a recommendation to the Minister as to whether or not the proposal should be implemented, and if so, the conditions that should apply. Probably the most famous case in WA environmental law is coastal waters, and in that case it was held that the EPA can only take into account environmental factors when it prepares its report to the Minister. At that point, an appeal can be made on the EPA reports to the Minister, so the Minister wears two hats in the process, firstly in deciding an appeal on the EPA report, and then ultimately the final decision as well. And we're currently running a case through the Court of Appeal on the ELIRI project, which touches on the appeals process as well. When the EPA report gets to the Minister, it sort of goes into a black hole, and the Minister consults with other decision makers, and then out pops a final decision. And the Minister can then, at that point, take into account non-environmental factors. That decision-making process isn't made public. So for ELIRI, the EPA recommended against the proposal, but the Minister decided in consultation with his Cabinet colleagues that the proposal should go ahead, but we never knew what the actual reason for approval was. He just produced his ministerial statement. And so that's the point we're challenging in the court. And with the ministerial statement, conditions are imposed as well, which often require management plans and actions throughout the life of the proposal. And at that point, only the proponent can appeal those conditions. So that's a race through the Part 4 process. Over to Part 5. Part 5 regulates native vegetation clearing, licensing, pollution and environmental harm offences. We're only going to touch on clearing permits today because it's more relevant to the people in the room. Of course, under Section 51C, it's an offence to clear native vegetation unless you have a clearing permit or unless one of the exemptions applies. And the exemptions, which are really complicated, often need lawyers or experts to interpret, sit in both Schedule 6 of the EP Act as well as the clearing regulations as well. And it's sort of, I guess, almost a choose your own adventure as to how to navigate the clearing regs as to whether or not an exemption applies. But when the regulations apply, the clearing can't occur in an environmentally sensitive area. In that case, you need a clearing permit, essentially. So for clearing permits, they're assessed either by DWER or DMIRS, depending on the activities. So the Department of Mines will assess most clearing permits for mining activities. And this is where I'm sort of starting to get into the role of the consultant and this in the process, because I'd say that the permit assessment and also the Part 4 process is reliant heavily on the quality of the survey information that comes before the department. That's because the department has to have regard to the clearing principles under the Act. So it doesn't have to follow them specifically or apply them, but it has to have regard to the clearing principles. And those clearing principles are set out in Schedule 5 of the Act. And I'll put them up on the next slide, and people here are more familiar with those even than me, I guess. But those clearing principles provide circumstances in which native vegetation should not be cleared. When the assessment's done, they normally assess it and consider whether the clearing is at variance with the clearing principles. And again, I'd say in undertaking that assessment, it's often reliant on the quality of information that comes before the department. And that's something that annoys a lot of our clients when we run appeals on clearing permits. Often the survey is incomplete, and we often challenge the assessment report on the basis that they've relied on inadequate information. And in doing so, that often will hold up the proposal as well, because when the appeal is being run, the clearing can't occur. The only requirement under the Act is that written reasons must be provided if the clearing is seriously at variance with the clearing principle. So I think it's a good thing that the department provides more information than is required under the Act, but under the Act, the written reasons are only required if the clearing is seriously at variance. So I've just put up the clearing principles just to refamiliarise yourself, or some of the clearing principles. But again, just to emphasise that it says that native vegetation should not be cleared if it's at variance with some of these principles. And so often we see that comes across my desk is clearing permits that have been granted that are at variance with multiple clearing principles, but no real reason as to why the clearing should go ahead. The assessment's done, and then often we'll just see the decision says, well, yeah, it's at variance with 3 of these or whatever, but no real reason as to why that clearing should occur, and that's why often there are so many clearing permit appeals being being run at the moment from a community perspective. So I guess moving on to the second part of the presentation, it's really around the role and importance of surveys in these EP Act processes. So firstly, say that it provides crucial information to inform the EPA and the other departments, including the Minister as well, in the environmental assessment and clearing permit process. They rely on that information, and often the community doesn't have access to consultants to test that information. The department might be under-resourced, so often it's people in this room who are providing the key information that goes forward in the assessment process. And it also relates to a lot of really key legal decisions that are made under the Act. For example, information goes to the EPA when it makes a decision as to whether or not to assess a proposal, even at that early stage, as to whether or not it considers the proposal as significant, as to the level of assessment, as to its recommendation about approval or not, and the conditions to be applied. Information that goes before the appeals convener. We're involved in an appeal at the moment where we say that the quality of the survey is poor, but essentially that's what the appeals convener is relying on in terms of deciding the appeal. Whether a clearing permit is required or an exemption applies as well. Like provide information to the client, is it in the ESA or not, those sorts of key decisions, and it can lead the client to be found guilty or liable for an offence if key decisions are made based on faulty information. So these processes are reliant on quality and accurate information. And as I'll get to in a minute, it's a public process, so it's not always just the client that relies on the information that is being provided on behalf of the client, but other people in the community see that. So what are the other legal and other considerations? I've sort of posed a few questions in this slide. The first thing is, are the people in this room obtaining an approval? Is your role to obtain approvals, or is it undertaking an assessment and playing a part in the assessment process? I guess the hint, particularly in the EP Act under Part 4, it's titled Environmental Impact Assessment. It's not about approval, and it's not about or refusal. And at the end of that process, the Minister makes a decision about implementation of the proposal, not approval. It's about whether or not a proposal can proceed into other areas of the Act as well. And that, I think people need to bear that in mind. And I used to have a role at Rio, the approvals manager, and I used to always call it approval. But when you really think about it, it's about assessing the environment around you. Also, how's the survey being undertaken, and who's going to rely on the information, which I've touched on? Is it the client? Is it the EPA? Is it the broader public? And there's quite a good legal article in the Environmental Planning Law Journal by Fisher, who says that there are a range of interests which environmental studies are likely to affect. And she said that it's conceivable that an environmental study may have to take into account each of these interests in a way that satisfies the contractual responsibilities of the consultants and their client, but also any other statutory and common law responsibility of a wider nature. So I guess whether they're entitled to or not, there are numerous parties who will rely on the information that you provide. Possibly the landowner, the purchaser, the lender to a project, insurer of a project, the developer of the resource, who might be a client normally, the government, the community, potential objectors, the list goes on. And they might not be entitled legally to rely on the information, but they will do in any event, because that's often the only information that's available to them, either in a due diligence or a review process. And I guess the other questions are, well, what are the client's imperatives? Is it driven by just getting approvals at any cost? Or is it the quality of the survey, the schedule, the project schedule? Or is it also, I guess, broader questions around their reputation and social licence as well, in terms of how they put together the approval or assessment, I should say. And I guess that then starts turning into, well, what are some of the legal and ethical obligations? And members of the ECA will know their code of conduct more than me, but I thought some of the codes of conduct of the ECA are quite relevant. For example, responsibility of members to the community will come before their responsibility to the profession, to sectional or private interests, or to other consultants. Members will not condone misrepresentation or misuse of work that they've carried out or directed. They'll uphold the honesty, standing and dignity of the profession. They'll maintain their skills and knowledge throughout their careers, so stay up to date with latest learnings and, I guess, inquire into new information. And they'll only practice in areas in which they're competent as well. And a lot of these are very similar to the code of conduct that I have to applied by the legal profession as well. And that's very much reflected in the Environmental Protection Act down at section 112 towards the end, which is the key offence provision that I guess we're all subject to in different parts of our role in the process, which states that a person who, in purporting to comply with a requirement made by or under this Act to give information to the EPA, the CEO, which is the department essentially under the Act, an authorised person or inspector, so if an audit's being undertaken, or a police officer, gives or causes to be given information that to his or her knowledge is false or misleading in a material particular commits an offence. So it's not just the operator of the mine site that can be subject to it, it's a broad range of different people in the process. If you're not careful about how your information is being used, and if you think it's being used in an incorrect way, you stick your hand up because it could have implications. And I think there are potential for this offence to apply for misleading surveys or surveys done incorrectly. And I've got a couple of case examples to touch on. But beyond, I guess, that scary kind of threatening criminal offence, there's other implications, I guess, for incomplete and inadequate surveys. The first, these are, for example, longer assessment and approval time, loss of public confidence, and licence to operate for the client or your consultancy. The appeals process, and again, I see a lot of appeals and community groups saying, oh, well, that consultancy did it, and they're no good, versus this one, and the reputation gets out there for shoddy jobs. And down the track, requirement for changes to approval. The minister's got the ability to call in approvals down the track if he or she's concerned that the conditions aren't correct, and often that can be as a result of poor planning up front or poor surveying. So I'm just going to race through a couple of these cases because we've only got a couple of minutes to go. And both of these are in New South Wales where there's a lot more litigation happening, but there's a chance that it could occur in WA. The first one involves a consultant, Oregon, who had essentially provided approvals advice for a company and effectively told the developer that it could clear a certain amount of koala habitat without a licence and that it didn't need a licence to undertake clearing of koala habitat. That cleared 7.3 hectares of high quality koala habitat was cleared and impacted a corridor link as well. A significant fine was imposed on the consultant as well as a requirement to undertake koala habitat mapping. So there's quite creative tools available to the courts in New South Wales in terms of what can occur if an offence happens. So that mapping cost the consultancy $150,000 as well as publication of that decision in a number of newspapers as well, which obviously affects the reputation of the consultant. The judge in that case said that the offences underscore the importance of consultants advising those engaged in the property development process to ensure they undertake work only within their area of competence. I surmise that these prosecutions will provide an important signal to those engaged in similar activities of the need to ensure that correct advice is given and I guess maintain up to date with the law and science as well. And the second case, which I think is even more relevant and interesting, involves a property owner in Sydney who needed some additional topsoil for a landscaping project. And the local council officers inspected stockpiles of soil that he imported onto the property and suspected there was asbestos present. So the property owner engaged a consulting firm, Argus, who's the subject of this case. The project manager went along to have a look at these stockpiles. He observed 2 pieces of suspected asbestos fibro cement, but he didn't see any other asbestos around. So he actually took that cement away and binned it. The Argus analysis, so they went and did their analysis of the soil anyway, and they didn't find any asbestos, and issued a classification report and said everything was fine and signed off on it. The council officers re-inspected the property and saw more pieces of this suspected asbestos in the stockpile. So they requested Argus to do another report, so the consultant had to go back and do more testing. And this did identify presence of asbestos in the stockpile and they recommended remediation. That's when the EPA got involved and they issued a clean-up notice, and they also seized the pieces of asbestos in the bin outside the project manager's office, which tested positively for several types of nasty asbestos. So it prosecuted Argus and its project manager and the environmental manager of the developer as well for breach of section 144A, which is pretty much the same as the section that I put up on the EP Act. They all pleaded guilty because it was a bit hard to get out of that offence. So the case really affected what was going to be the penalty imposed. What was interesting is the project manager admitted that statements in the initial reports that no asbestos fibro was observed was misleading, and he'd in fact observed it, so he admitted that was the case. But he said, at the end of the day, we're there to help the owners, we're there to engage by the owners of the site, and it wasn't my intent to be misleading. So that's what he said to the prosecutors before the case, and that didn't obviously go down that well with the court. And the environmental manager made similar comments about, well, we're there just to help the project rather than the broader interests, and that we didn't try to be misleading. So the court was very concerned with the consultant's approach and imposed a fine, and there was some quite heavy comments from the court in relation to that case. Interestingly, the EPA sought some more creative penalties, such as publication of the offence in national newspapers like the Sydney Morning Herald, etc. Because there was no actual harm caused out of it, the court didn't award those penalties, but still required publication in more scientific and industry-based journals, which I'd say is just as harming for the consultant. But I'd say that risk is still possibly available in there in WA as well, because it's a very similar provision. So it's not quite linked to surveys and botanists, etc., but you can sort of draw the connection there. So that's a bit of a race through, but I've just hit the time.
Sorry.
That's all right. So that ends my presentation. Happy to take questions.